Welcome everybody to this video. This is part one of State versus Dawes, case number 14 CT 66525. Now, my disclaimer is that I'm not an attorney. I don't have a license to practice law. I do not practice law. What I do is study law and tell people what I've learned and how I've gathered the information. So I'm not going to give you information as advice to apply to your specific case, but it's general information regarding the law and lawful principles, which, by the way, do belong to the people. So please use any information obtained in this video for educational edification only. And the reason I say that is because I want nothing I say to be construed to be legal advice. If you feel you need legal advice, I would highly encourage you to hire a licensed and hopefully competent attorney and be legally advised. Now, with that being said, as you continue through the video, if you enjoy this video and many of the other ones that are on the site, you can go to my website, which is gregdoss.com. Look at our services that we provide, and you'll, see quite a few things that we've done along the way, me in particular, as far as my experiences within the court system. And of course, you can always contact me directly. The phone number and my email information is on that website. Now, what you're going to hear in this video is audio from my very first case as a pro se litigant. And I'll say this, I've definitely evolved from where I was in this video. My approach to the court, which of course is the judge, and in this case it was Judge Conrad, is definitely changed over time. My pacing has gotten better, and to be quite honest, I was pretty nervous because a lot of the information I got prior to going into this particular journey or on my journey as a pro se litigant came from the internet, came from the various people who would tell you or say how to go through a court session and what you can learn and how to make things happen. Some of it, I can't say for a fact, did work. I think basically it came down to my presentation as it related to issues of law, issues of fact, and the things that could and could not be proven. And you'll see as we continue to go through here. Now, the language I used during this particular arraignment and throughout the proceedings is a bit different than the language you'll hear from me in later proceedings, particularly different cases. And I've had successful outcomes in, I believe, 7 or 8 cases involving driving without a license suspended. Now, of course, I'll provide a narrative for some of those other cases as well. But what we're saying is, what I'm telling you is, you'll learn quite a bit from this. I'm not saying to use exactly the way I went about it, particularly in this case, because I think I got a little bit lucky. I'm going to give you some background on this action and the arraignment for this action, which is the first appearance, an arraignment, which of course is the first appearance of being charged in Florida, traffic proceeding in Florida, whether it's civil or criminal, you get what's called an arraignment. I was stopped for driving my license suspended. Well, actually, I don't know why I was stopped. The charge from the stop was driving my license suspended. I don't recall all of the reasoning for the stop again, but I got stopped nonetheless and ended up in court to defend this action. So for those keeping score, I did not go to jail for this stop. However, a ticket does constitute an arrest for speedy trial purposes. And I definitely got arrested several other times for driving my license suspended. So continue to follow my cases. That issue will be addressed in later cases, particularly a case involving Judge Farr, where that's a different issue altogether with him. But let's not forget that speedy trial is definitely important when it comes to criminal allegations of any kind, whether it's misdemeanor or felony. Check your state for the exact time or what have you, or how they go about dealing with your speedy trial issues. So now, without any further ado, you can listen to the audio of me dealing with Judge Conrad, which again, he's going to be pretty honorable. I'll at the end of this audio for the arraignment, I'll come back and we'll discuss a little bit more, but listen to the audio, listen to the arraignment, take notes. Hopefully none of you all find yourself in this situation as I found myself in several times. I do have my license now. That's another part of this story, which is incorporated in my journey. You'll be able to see how I managed to get my license back, to include even after they try to take it again.
Is that you, sir?
Yes, I'm here as the agent for this situation.
Okay, so let's slow down 1 second. An agent for who?
I own that entity, Shugret Dawson. I've already filed a couple of documents, one of which is a challenge to the statute.
Okay,
And,
well, listen, let me explain how this works. You've been in this division before?
Yes, sir.
Okay, when you file something, okay, it has to be filed with the clerk of court. If it's a motion or a request, it has to be filed with a notice of hearing. If it's not filed with a notice of hearing, I'm not going to, you can roll your eyes all day long. I'm not going to listen to it. I'm telling you the procedure. If you want to represent yourself, you follow the procedure. I'm going to treat you like you're a lawyer if you want to take that responsibility. This is how it works. If you want to file something for me to consider, it has to be done with a notice of hearing. You're going to file it with the clerk of court. You're going to give the state attorney a copy of whatever motions you want to file, and you're going to send a courtesy copy to my office so that I can review it ahead of time prior to the notice of hearing, okay?
Okay.
That's
Well, I overstand that, so I didn't realize I was rolling my eyes. There's no disrespect intended, but let the record reflect that I'm here in propria persona and under special appearance, which actually has been filed with the state attorney's office.
Well, but I don't have any of that in the court file.
Well,
In other
I have
words,
a copy.
But it's not, but
It's
you
not
can
in the
give
file,
me.
that's fine. We can take care of that.
Listen to me, listen to me. I don't have a problem with you representing yourself. I don't have a problem with you objecting to my jurisdiction. I don't have a problem with you believing anything that you truly believe and presenting that in a reasonable fashion to the court. I'm going to respect what you want to do, but it has to be done in a way that's consistent with the way that these matters are handled in front of me. And so if you want to file a request to have something dismissed, I'll be happy to listen to that. Whatever arguments you want to make, I'll give you time to do that. I'm just not doing it today.
Overstood.
Okay, so listen, you want to plead not guilty, right?
I wish not to enter a plea at all because I don't know the nature and the cause of this accusation.
Okay, so here's what we're going to do. The charge is driving with a license suspended with knowledge on April 17, 2014. It's a second-degree misdemeanor offense. When you file papers, are you going to request information from the state or not?
I already put those in. The
Does
state
he have a
attorney has
request
one.
for you or not?
It was filed and it was actually date stamped.
We
on
had,
May the 2nd.
I
you
mean,
have a
it's not a
request?
demand for discovery. I don't
It is
see
a
that
demand.
in here, but I'm happy to take note of that and get that.
You can have that one. That one's for you.
Okay, so here's what we're going to do.
Okay, yeah.
But again, here's the thing. Everything that you, I'm going to say it one more time. Everything that you do that's a legal paper has to be filed with the clerk of court, or there's no record of what you're doing, and then I don't have a matter that's properly filed before me to consider. So if you try to raise matters that have not been filed with the clerk, I'm going to unfortunately summarily deny them or not listen to them because they're not properly in the record. But I'll listen to whatever you want to raise if it's filed in the record.
Well, I don't want to do it, and I could do it, I guess, an oral motion, but I thought it was actually in, and it actually has been date stamped. And if you want a copy, I provided one for you as well.
Well, I already told you what you're going to file.
Okay,
You're gonna
I'm fine
file-
with that.
Well, you can be fine or not. You can file the original with the court, with the clerk of court, and then we'll get a notice of hearing for you, and I'm happy to listen to your arguments and whatever. The state's going to give you information about what they believe the case is. I'm actually today going to give you your driving record, which lists what may be on record with the Department of Motor Vehicles, and explain potentially why the officer may have believed your license was suspended. So you'll have this information available to you, and that'll be the information that most likely will be the evidence in the case, if the case goes forward, okay?
Appreciative, sure, I appreciate
Let
it.
the record reflect, I'm giving Mr. Doss a copy of the driving record that was in the court file. The date that the record was generated was April 25th of 2014. What's your request today? Do you want to set the case for trial?
Well-
And then between now and then, I'll listen.
That's fine, you can
Okay.
set it off, but no plea is going to be entered, and let the record reflect that as well.
Well, I'm going to enter a plea for you.
We have
You can do your notice of special appearance. I understand how that works.
And we
But
have
we're going to
an
move
issue
the
of
case forward.
practice
I'll
of law
rule
from the
on that
bench
issue
also.
about jurisdiction at a future point.
Okay.
And if I agree with you, then I'll dismiss the case. All right, what was the position of the state? He's not going to be HTO'd, right?
Just an adjudication, court cost prosecution.
All right. When do you want to set it for trial?
Jury or non-jury?
No, I'm the non-jury trial.
Yeah,
It's only a
I
second,
would
right?
object to that.
You're welcome to object to
I just
that.
wanted to make it on the record.
Sure.
I'd say 3 to 4 weeks out should be fine.
Will that give you enough time to prepare and have your
Well, that's
motions
kind of
heard?
difficult to do in as much as you've yet to provide a causation for the stop, and I have no information. You have an
April, May,
affidavit
June, July.
supported by somebody that
Okay,
states that they
here's
were
what we'll
injured.
do.
I'm
Let's
talking
give-
to you, State.
Listen, okay,
No, I
well,
know.
you're speaking, I can, All right, I'm going to set it for a non-jury trial. It'll be July the 1st at 9 o'clock, gives you almost 2 months, okay? You'll get a piece of paper with this, okay? Whatever you want to do in terms of having motions or matters heard before me, you need to, again, get a notice of hearing from my judicial assistant. I'll write my phone number down here. You can call her. When you call her, all the matters that you want have to be ready to be filed, okay?
That's fine. I'll be
Good
ready.
deal. All right, we'll see you on July 1st at 9 o'clock unless you have matters scheduled before, and then I'm happy to listen to those issues and rule accordingly at the hearings, okay?
Would you like the copies that I provided?
Just do it with a notice of hearing and call my clerk, and I put my number there for you to contact her, okay? Say versus Christopher Durr.
Okay, everybody, I'm back. Now, I would not suggest taking the same approach as I took in this initial encounter, but I would definitely take the same stance. I don't regret going through the process, and again, I was quite nervous because I was definitely expecting at some point for them to just rush me and throw me in jail, especially considering a lot of the information I'd received up to that point. But because Judge Conrad is an honorable gentleman, almost like a professor, I was able to learn a lot from this experience, and I used it moving forward. So just keep in mind, this is just part one of this case. Check later for the next 3 sessions leading up to a dismissal of this action. And I'll leave you again with my disclaimer. I'm not an attorney. I do not practice law. I don't have a license to practice law. I study law. I share what I've learned through my experiences with everybody. The information is public record anyway. If you wish to find out more about me, go to gregdoss.com. You can book a session. You can see all the services that we offer there as a consultant for self-represented litigants. Again, I do encourage everyone to, at some point, if you happen to have a situation, attempt to consult with an attorney just to get some background information. Again, if you like what you see here, you can always support the channel by using my Cash App, which is on my website. You can support us through Zelle, and definitely support us through PayPal. And it's always important, peace and chicken grease, because sometimes it's not about right or wrong. More importantly, it's about clarity. You'll never reach resolution if you're not willing to engage in honest dialogue, even if that dialogue is with yourself. Take time to hug the person you love and love the person you love. I'm Greg Dawson, Greg Dawson, attorney pro se consultants, or GDNAPSC. Peace and chicken grease. I'm out of here.